it's why this strict scrutiny, application of the strict scrutiny test is why many analysts believe that the days of affirmative action are numbered, for example, in university admissions. Many universities have, for many years, used race as a criteria for admissions, where critics argue that it's an affirmative action program that gives advantage to racial and ethnic minorities when they apply for university admissions, and many people who are opposed to affirmative action cry that it's nothing more than reverse discrimination. What I'm trying to, those arguments aside, and boy, there are lots of good discussion there that we can get into, and policy arguments and so on that we can get into. But what I'm trying to get you to understand is that many analysts, regardless of which side of the issue that they're on, seem to agree that the days of affirmative action in university admissions, for example, are numbered because, like it or not, it discriminates on the basis of race. And the court says, the court's view is that any laws or policies that discriminate on the basis of race are unconstitutional unless an overwhelming justification can be provided. Now, up to now, universities apparently have been able to satisfy that. There was a case that came out of the University of Texas back in 2013 involving a young woman from Sugar Land, Texas, called Fisher versus Texas, which many people viewed as the case where the Supreme Court would finally strike down affirmative action and the use of race in university admissions, but the court actually did not. It actually decided the case kind of on a very narrow question and left the sort of broad question aside. But who knows? There may be another case coming up the pipeline in the near future where we'll have finally an answer to that question of whether or not universities can take race into consideration in admitting students. If it is a law or a policy that discriminates on the basis of gender, the court sees gender as being an almost suspect category. Now, those of you who are particularly concerned about women's rights, gender equality, might very justifiably wonder, well, why does the court see gender as only an almost suspect category and not a suspect category? And again, I probably don't have an answer that's going to satisfy you in terms of your desire for that to be treated the same as race, except to say we have to look to the history of the framing of the 14th Amendment. And there's really no evidence that the framers of the 14th Amendment were particularly concerned about gender equality. They were concerned about racial equality. And by the way, that's probably a big part of the argument why you now have some effort to revive the so-called Equal Rights Amendment, which was originally proposed back in the 1970s, which was never ratified to the Constitution, but there have been some murmurings that we should make a second effort at passing the so-called Equal Rights Amendment that would eliminate or attempt to eliminate discrimination on the basis of gender.